Effects on trial proceedings. The Peace Officer Bill of Rights, as integrated into various state statutes and collective bargaining agreements, has had far-reaching effects on the legal and judicial processes surrounding police misconduct cases. While these provisions were originally intended to secure fair treatment for officers under investigation, critics contend that their implementation has influenced the frequency and nature of trials and complicated the evidentiary discovery process. Over time, these dynamics have contributed to a legal environment in which trials are often reduced in number or significance, and the process of gathering, disclosing, and examining evidence may become constrained. Understanding these impacts is critical to evaluating how POBR frameworks shape the pursuit of accountability, influence prosecutorial strategies, and affect public perceptions of the justice system's integrity. Reduction in trials. One of the most salient impacts of POBR legislation is the observed reduction in the number of full trials that reach the courtroom. Internal investigations governed by POBR provisions often involve lengthy and complex procedures intended to safeguard officers' due process rights. These procedural steps may, in some cases, encourage resolution of cases through alternative means, such as administrative settlements, plea arrangements, or disciplinary actions negotiated outside the public eye. The rationale underpinning these protections is that law enforcement officers, who operate under substantial pressure and risk, should not be subjected to arbitrary or politically motivated prosecution. However, critics argue that these provisions have, as an unintended consequence, streamlined pathways that steer complaints and allegations away from open judicial forums. Several factors contribute to this reduction in trials. First, POBR statutes often impose stringent procedural requirements on investigators, limiting how and when evidence can be collected. Strict timelines, mandatory notifications, and constraints on investigative methods can inadvertently hamper the ability of prosecutors to gather sufficient, timely evidence to meet the burden of proof for criminal charges. In a practical sense, if critical evidence is delayed, withheld, or rendered inaccessible by procedural hurdles, prosecutors may be more inclined to pursue plea agreements or to recommend that cases be handled administratively. This approach avoids the high bar set by jury trials, where the standard of proof is beyond a reasonable doubt, and where a jury might be critical of any perceived investigative shortcomings. Second, POBR-related provisions can create an environment that incentivizes early settlement. When the internal investigative process itself is arduous and time-consuming, departments and municipalities may prefer to resolve cases quietly rather than risk protracted legal battles. The result can be a decline in open court adjudication of misconduct cases, further reinforcing a pattern in which trials become exceptions rather than the norm. While this may save time and resources, it also raises questions about transparency and public trust. Observers have expressed concern that bypassing trials sacrifices the informative and corrective functions of open litigation, which can expose departmental problems, highlight systemic issues, and inform future reforms. This reduction in trials has broader implications for the legal system. Fewer trials mean fewer opportunities for public scrutiny, judicial precedent, and the detailed fact-finding that occurs when evidence is tested before a judge and jury. The absence of a robust trial process can hinder the development of legal standards and limit the judiciary's role in shaping the boundaries of acceptable police conduct. Without the guiding influence of trial verdicts, legal frameworks that govern law enforcement behavior can remain static, less adaptive, and disconnected from evolving community expectations or reform initiatives. Impact on evidentiary discovery. Beyond their influence on the frequency of trials, POBR provisions have a profound impact on the evidentiary discovery process. By setting conditions and limitations on how and when evidence can be obtained and disclosed, these statutes can hinder investigators, prosecutors, and defense counsel from conducting thorough inquiries. While some restrictions are justified as ensuring fairness and preventing fishing expeditions, others may be perceived as facilitating a form of selective opacity that shields officers and agencies from comprehensive public and judicial oversight. One commonly cited issue is that POBR statutes often restrict the timing and manner of interrogations. Investigators must frequently provide advance notice before questioning an officer, specify the nature of the alleged misconduct, and may be required to conduct interviews only during certain hours or under controlled conditions. Although intended to prevent coercive or abusive interrogations, these limitations can also reduce spontaneity and limit the potential to gather candid, unfiltered information that might emerge from less scripted questioning techniques. As a result, key details may remain undisclosed, and investigative leads may never be fully explored. Additionally, POBR frameworks may limit the disclosure of critical documents and evidence to outside parties. Personnel records, internal memos, and disciplinary histories are often shielded or released only under tightly regulated conditions. While protecting the privacy of officers has a legitimate basis, it can also prevent plaintiffs, defense attorneys, and prosecutors from gaining a complete picture of an officer's conduct over time. Without access to patterns of behavior, prior complaints, or previous findings of misconduct, it is more challenging to establish credibility issues or to identify systemic problems within a department. In some jurisdictions, union contracts and collective bargaining agreements supplement POBR protections, further limiting access to information. These agreements may require that certain files be destroyed after a set period, restrict the type of evidence that can be publicly disclosed, or mandate that internal investigations be kept confidential. Russian, 2017. Such provisions can impede efforts to assemble a robust evidentiary record, both in individual cases and in broader analyses aimed at understanding the prevalence and causes of misconduct. The cumulative effect is a narrowing of the evidentiary pipeline, making it more difficult for courts, oversight bodies, and the public to assess the merits of allegations and ensure that accountability processes are both fair and effective. The implications for prosecutorial strategy are significant. Without ready access to a comprehensive evidentiary base, prosecutors may struggle to build a persuasive case. This can lead them to rely on negotiated resolutions or to decline prosecution altogether in borderline cases. Defense attorneys representing plaintiffs in civil rights lawsuits face similar hurdles. When evidence is confined or delayed, plaintiffs may find it difficult to prove their claims, resulting in more settlements or dismissals that never undergo rigorous judicial scrutiny. Conversely, defense attorneys for officers can leverage POBR-related restrictions to challenge the admissibility or sufficiency of certain evidence, potentially weakening the plaintiff's case and encouraging early resolution. Over time, these evidentiary challenges can create a feedback loop. Prosecutors who repeatedly encounter difficulty gathering necessary evidence may develop a general reluctance to pursue certain cases, especially those involving complex allegations of misconduct. The perceived difficulty of obtaining relevant records or testimony can discourage the filing of charges, thus further reducing the likelihood of trials. In this manner, evidentiary constraints do not merely affect individual cases. They shape prosecutorial incentives, departmental practices, and the overall complexion of police accountability in the judicial system. Finally, these discovery limitations raise concerns about public confidence. If trials become rare and evidence remains inaccessible, community members may question the fairness and legitimacy of outcomes. Suspicion may grow that the system is designed to protect officers at the expense of transparency and justice. This erosion of trust can, in turn, fuel calls for legislative or policy reforms aimed at dismantling or revising POBR protections, loosening restrictions on discovery, and ensuring that evidence relevant to allegations of misconduct is made available for judicial scrutiny. Contemporary reforms and future outlook. In recent years, some states have begun to reconsider the balance that POBR statutes strike between officer protections and evidentiary openness. Reforms aimed at increasing transparency, reducing confidentiality provisions, and facilitating earlier disclosure of key evidence have gained traction. While these changes remain incremental and face opposition from powerful police unions and supporters of the status quo, they suggest that the landscape is not static. Legislative bodies, advocacy groups, and oversight commissions are debating whether the cost of restricted evidence, fewer trials, diminished public trust, and a narrowed pipeline of information is too high a price to pay for the procedural safeguards POBR intends to provide. As new data emerges and public scrutiny intensifies, the legal system may inch closer to models that preserve essential due process protections while facilitating more robust evidentiary discovery. Such recalibrations could encourage a return to more frequent trials, ensure that fact-finders have access to the fullest record possible, and restore some measure of public confidence in the accountability mechanisms that govern police conduct. Ultimately, resolving the tension between procedural fairness and evidentiary openness will require careful policy design, informed debate, and a willingness to adapt legal frameworks as the understanding of best practices and community expectations evolve. In conclusion, the effect of POBR provisions on trial proceedings and evidentiary discovery is profound and multifaceted. By reducing the frequency of trials and constraining the scope of accessible evidence, these frameworks have reconfigured the landscape of police accountability within the judicial system. Although these changes were driven by legitimate concerns for officer due process, their long-term implications raise pressing questions about transparency, fairness, and the capacity of the courts to serve as arenas of truth-seeking and justice. As stakeholders and reformers continue to scrutinize POBR laws, the challenge will be to find a workable equilibrium that honors both the rights of officers and the imperatives of accountability, integrity, and public trust. Role in obfuscating disclosure requirements. The Peace Officer Bill of Rights has exerted a profound influence on the legal and judicial processes surrounding police accountability, not only by shaping investigative and disciplinary procedures, but also by affecting the accessibility and clarity of critical information. A central criticism levied against POBR frameworks is their role in obfuscating disclosure requirements, both those mandated by constitutional principles, such as Brady and Giglio, and those outlined by state laws and departmental policies. This obfuscation can manifest through restrictive provisions governing the release of officers' personnel files, internal investigative reports, and related documentation, often to the detriment of transparency, fairness, and the effective administration of justice. Framework of disclosure requirements. In the American legal system, prosecutors are obliged to disclose exculpatory and impeachment evidence to defendants under precedents like Brady v. Maryland, 373 U.S. 83, 1963, and Giglio v. United States, 405 U.S. 150, 1972. These requirements ensure that the accused can mount an informed defense. The underlying rationale is that justice depends upon a full and fair disclosure of relevant information. However, in cases involving alleged police misconduct or the reliability of officers' testimonies, such evidence may be located within personnel records, disciplinary histories, or internal affairs investigations that POBR statutes often cloak in confidentiality. In addition to constitutional disclosure mandates, many states and municipalities have enacted their own laws or administrative rules requiring that relevant information be made available to counsel and, in some cases, to the public. These statutes are intended to further transparency, enhance the integrity of the judicial process, and deter misconduct by ensuring that information about prior complaints or substantiated misconduct is not hidden from scrutiny. POBR as a shield against disclosure. POBR provisions frequently include language that restricts or regulates the release of personnel files, disciplinary records, and other internal documents. Although these restrictions are often justified as necessary to protect the privacy and due process rights of law enforcement officers, they can also obstruct legitimate attempts to access information essential for proper adjudication. Limitations may take the form of requiring judicial orders to release files, imposing stringent criteria for what constitutes relevant information, or delaying access until certain internal review steps have concluded. Each additional procedural hurdle, however well-intentioned, can function as a barrier to timely and complete disclosure. In some jurisdictions, collective bargaining agreements and union contracts have further reinforced POBR-like protections, reinforcing complex layers of confidentiality. These arrangements may forbid the disclosure of certain investigative reports to external parties or mandate the sealing of disciplinary findings, after a specified period. Such provisions not only impede prosecutors seeking relevant evidence for criminal trials, but also hinder defense attorneys and civil litigants who require access to these materials to build a robust case. When crucial evidence is obscured or delayed, the judicial process is deprived of essential insights, and the fairness of the proceeding can be compromised. Impact on prosecutorial decision-making. The obfuscation of disclosure requirements under POBR frameworks places prosecutors in a difficult position. While prosecutors are constitutionally obligated to disclose exculpatory and impeachment material, the structural impediments created by POBR can render it challenging to identify, obtain, and review such evidence. Without straightforward, timely access to officer histories, internal affairs files, or prior misconduct findings, prosecutors may be unaware of critical information that could affect the credibility of testifying officers. Incomplete disclosure can lead to wrongful convictions if exculpatory evidence remains hidden, or conversely, can undermine trust in the prosecution if allegations arise that prosecutors failed to disclose known misconduct of testifying officers. Over time, prosecutors confronted with these recurring challenges may alter their strategies. Some may choose to refrain from calling certain officers as witnesses if their credibility cannot be thoroughly vetted. Others might rely more on plea bargains to avoid the uncertainties and evidentiary hurdles of going to trial without complete information. Both scenarios have systemic consequences. The first may reduce the pool of reliable law enforcement witnesses, and the second can limit the instances in which evidence is fully examined by a judge or jury. Defense challenges and the erosion of fairness. Defense attorneys face a parallel set of difficulties. Defense counsel are entitled to evidence that could impeach an officer's testimony, reveal patterns of misconduct, or demonstrate a lack of credibility. Yet, POBR rules can stymie efforts to discover and present such material. Layers of administrative red tape, confidentiality clauses, and limited disclosure channels can force defense teams to rely on incomplete information or engage in lengthy legal battles, such as filing motions, litigating subpoenas, or appealing disclosure denials, all in search of documents that should be readily available for the pursuit of justice. The cost, in terms of time, resources, and uncertainty, further disadvantages defendants, especially those with limited means. When the defense cannot obtain key evidence due to POBR-imposed constraints, the principle of a level playing field is eroded. Trials become more about negotiating procedural barriers than about revealing the truth. This dynamic can distort outcomes, leaving juries and judges to deliberate without a full understanding of potential officer misconduct or credibility issues that could materially affect the case's disposition. Implications for civil litigation and public accountability. The obfuscation caused by POBR does not solely affect criminal proceedings. In civil litigation, particularly lawsuits alleging unconstitutional policing or excessive force, the difficulty of accessing relevant law enforcement records can stifle plaintiffs' efforts to establish patterns of misconduct or supervisory negligence. Without comprehensive disclosure, plaintiffs may struggle to demonstrate that a given incident was not an isolated occurrence, but part of a broader organizational failure. Such limitations can reduce the likelihood of successful civil claims and consequently dampen the deterrent effect these claims have on misconduct. Moreover, limited disclosure also affects the broader public's confidence in the justice system. When the public learns of repeated instances in which vital records remained undisclosed or were only released after protracted legal fights, trust in institutions diminishes. Communities may suspect that POBR frameworks are not merely protecting officers' legitimate rights to fair treatment, but are actively shielding wrongdoing from scrutiny. This perception can create a cycle of suspicion and resentment, driving public demand for reform and increasing tension between communities and law enforcement agencies. Legislative and judicial responses. In response to mounting concerns about obfuscated disclosure, some states have begun to revisit their POBR statutes. Reforms aimed at increasing transparency, such as narrowing confidentiality provisions, allowing limited public access to certain disciplinary records, and reducing procedural barriers, have gained traction in legislatures and among advocacy groups. These reforms often encounter resistance from police unions and some policymakers who remain concerned about officer privacy and potential politicization of disciplinary records. Nevertheless, the growing recognition that opaque disclosure rules can undermine the fairness and efficacy of the justice system is prompting incremental changes. Judicial interpretations also play a role. Courts have occasionally taken a more assertive stance, ordering the release of records when the public interest in accountability outweighs the privacy interests at stake. In these instances, judges may articulate standards for evaluating whether and how POBR restrictions should yield to disclosure demands. Over time, a body of case law may emerge, offering more predictable guidance on when confidentiality must give way to the constitutional and statutory imperatives of disclosure. Future directions and reform possibilities. The persistent tension between POBR protections and disclosure obligations suggests that future policy debates will likely focus on finding a more optimal balance. Policymakers face the challenge of ensuring that officers retain due process protections while not enabling a culture of secrecy that hampers the legal process. Proposed reforms might include establishing independent oversight boards with limited access to disciplinary records, ensuring these boards have the authority to review complaints and share relevant findings with courts. Alternatively, states might refine statutory language to specify the types of documents subject to disclosure and clearly delineate conditions under which confidentiality must yield to public interest. Another potential avenue involves integrating technology and standardized reporting systems. By creating centralized, secured databases with tiered access, states could ensure that prosecutors and defense counsel receive prompt and consistent information about officer misconduct. Such systems could operate under court supervision, balancing privacy and oversight considerations. The goal would be to reduce the arbitrariness and complexity that currently characterize the disclosure process under POBR influences. Conclusion. The role of POBR frameworks in obfuscating disclosure requirements is a critical, albeit often overlooked, dimension of the ongoing debate about police accountability. By complicating the pathways through which information can be accessed, POBR provisions can limit the judiciary's ability to ascertain the truth, impair prosecutors and defense attorneys' advocacy, and erode the public's trust in policing institutions. Although these statutes emerged from a desire to safeguard the procedural rights of officers, their real-world consequences on disclosure have raised fundamental questions about whether existing balances serve the broader interests of justice. As scholarly research, public scrutiny, and legislative initiatives continue to shed light on these issues, the legal landscape may gradually shift toward more transparent and equitable solutions that honor both the rights of officers and the imperative of accountability. Influence on police accountability. The Peace Officer Bill of Rights has played a significant role in shaping the legal and judicial processes related to police accountability in the United States. Enacted to protect the procedural due process rights of officers, these statutes have, over time, influenced the capacity of courts, oversight bodies, and the broader public to hold law enforcement personnel responsible for wrongdoing. While POBR provisions were intended to ensure fair treatment in disciplinary matters, critics argue that they have complicated efforts to enforce accountability standards, particularly when it comes to investigating and prosecuting police misconduct. One key way POBR frameworks affect police accountability lies in the restrictions they impose on internal investigations and disciplinary proceedings. By stipulating structured interrogation procedures, limiting the timing of interviews, and sometimes restricting the admissibility of certain evidence, POBR provisions can inadvertently slow or narrow the scope of inquiries into alleged misconduct. Investigators may be compelled to follow strict procedural steps that, while designed to prevent abusive or coercive tactics, also limit flexibility and inhibit a thorough examination of the underlying facts. Consequently, departments may struggle to build cases against officers who engage in inappropriate behavior, leaving misconduct insufficiently addressed. The influence on accountability extends beyond internal investigations to the realm of judicial scrutiny. Trials are essential forums for evaluating evidence and determining culpability. However, POBR provisions that restrict evidence disclosure or delay the release of critical information can diminish the capacity of courts to serve as impartial arbiters. When prosecutors and defense counsel cannot access complete officer histories, disciplinary records, or internal affairs documents due to POBR-related confidentiality clauses, the fact-finding process becomes less robust. This evidentiary obscurity can reduce the frequency and fairness of trials involving police misconduct, as the legal system struggles to obtain the documentation and testimony needed to assess allegations fully. In the broader context of police accountability, transparency and public trust are integral. A healthy accountability framework requires that the public can witness and understand how misconduct claims are handled. POBR statutes, by imposing layers of confidentiality and procedural barriers, risk fostering public skepticism. Communities may perceive that these regulations serve not only to protect officers' legitimate rights, but also to shield them from scrutiny. Over time, such perceptions can erode trust in the institution of policing and in the legal processes designed to oversee it. The complexity of these dynamics becomes clearer when examined comparatively. Some states that have more restrictive POBR laws experience heightened challenges in disciplining officers or holding them liable for misconduct. By contrast, jurisdictions that have adjusted or reformed their POBR frameworks, perhaps by allowing limited disclosure of disciplinary records or by streamlining investigative protocols, have begun to see incremental improvements in accountability outcomes. Legislative reforms, mounting public pressure, and a growing body of research calling for balanced approaches have encouraged states to reconsider the scope and implementation of these statutes. In essence, while POBR legislation has its origins in the legitimate goal of protecting law enforcement officers from arbitrary punishment, its effects on legal and judicial processes have raised fundamental questions about accountability. Striking a balance between officer rights and public expectations of transparency and integrity remains a challenge. As policy debates continue and reform efforts advance, lawmakers and stakeholders must carefully weigh the influence of POBR on police accountability, aiming for frameworks that uphold justice, transparency, and public confidence.